Welcome to today's program titled New Era, New Litigation, Lawsuits You Can Expect in the Post-Pandemic Environment. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to James McGrath. You may begin.
Thanks, Michelle, and welcome, everyone. I'm James McGrath, a partner in Seyfarth's Boston office, and I've got the pleasure of moderating what I think is a terrific panel of speakers today. This is the second installment in our post-pandemic litigation series. Our first installment, Court is in Session, the Post-Pandemic Courthouse, aired last week and addressed how we are likely to litigate for the indefinite future in the remote and virtual environment that we find ourselves today. This installment will focus on what we are likely to be litigating about, and we hope you enjoy the program that we're about to present. Before we get into it, I want to do a little housekeeping. Today's session is obviously designed to provide general information, not legal advice. But if you'd like legal advice about your specific situation, please contact one of our speakers, and they'd be pleased to provide it to you. I'm joined today by 6 of my partners, each of whom is a subject matter expert in one of the trending areas that we've identified. In Chicago, we have Christine Argentine, who chairs our Commercial Class Actions Group. From Houston, we have Jesse Coleman, who co-chairs our Healthcare and Pharma Group. In Washington, D.C., Tanya Espino co-chairs our Consumer Financial Services Litigation Group. Rick Lutkus is a partner in our Cybersecurity Group in San Francisco. Kate Schumacher is a partner in our Securities and Financial Litigation Group in New York. And finally, Rebecca Woods co-chairs our Commercial Litigation Group in Atlanta. Our panelists will provide an overview of the trends that we're seeing in these various areas based on the economic disruption, the social interference, and the health threats that are presented by COVID-19. They'll also offer specific tips to help you and your companies prepare themselves to address the challenges and disputes that you're likely to see in these areas. Obviously there's a lot to cover here, and we'll only be able to scratch the surface today. But our post-pandemic litigation series will continue with deeper dives into these various areas and others. During the program, you can submit questions through the Q&A function on your screen, and time permitting, we'll try to answer them at the end. Let me now turn it over to Tanya Espino, who will discuss the trends she's seeing in our bankruptcy and financial services litigation area. Tanya?
Thanks, James, and thanks everyone for joining us today. As James mentioned, I am the co-chair of the Consumer Financial Services Practice Group at Seyfarth, and I'm going to spend some time speaking today about the trends that we're seeing in litigation, and also talking briefly about some ways that you can prepare for what we anticipate will be upcoming or forthcoming litigation. So in terms of trends, to date, the majority of post-pandemic financial services litigation we've seen concern the banks or financial services institutions' facilitation of the Paycheck Protection Program. And so the Coronavirus Aid, Relief, and Economic Securities Act, or as we all know it to be the CARES Act, provided for $349 billion in forgivable loans to pay employees and cover certain operating expenses during the COVID-19 crisis. And so many of the banks are now involved, obviously, in making these loans through the Small Business Administration and are facing actual and threatened class action litigation. And we've seen a variety of these types of litigations filed. And some of the theories advanced in these purported class actions include allegations that the defendant banks violated the CARES Act by prioritizing borrowers with existing lending relationships and did not allow applicants without those relationships to access the funds, and that the banks were actually engaging in unjust enrichment. And at least one court has rejected that theory, finding that the CARES Act does not provide a private right of action, and the statutory language does not constrain banks so that they're not prohibited from considering information when deciding who to provide the PPP loans to and what process to follow. Another theory we've seen are defendant banks, allegations that the defendant banks prioritize applications from borrowers seeking higher loan amounts to generate what would be higher loan origination fees. And these cases are primarily in California and rely on California's unfair competition law to essentially accuse the banks of violating unfair, fraudulent, or unlawful prongs of that statute. So pretty original way of using that statute and bringing those allegations. And there's also some claims we're seeing of violations of the state's false advertising law and engaging in common law fraud. And yet another theory we've seen here is an antitrust theory, according to which there's a theory of recovery against the defendant banks alleging a tacit agreement among major banks to limit PPP applications to existing customers in a way of engaging in anti-competitive conduct in violation of the Sherman Act and the Clayton Act. And we've also seen in those litigations, defendant banks, allegations against the defendant banks of negligence and making negligent misrepresentations in connection with the PPP application process, and other allegations of preferential treatment. So another type of post-pandemic CARES Act litigation we've seen a lot of, and that is already out there being litigated, is stimulus check garnishment. And probably the most widely reported one is a federal class action lawsuit that was filed in Washington, D.C. that alleges that despite the prohibitions set by the CARES Act, the Secretary of Education, Betsy DeVos, illegally seized paychecks from federal student loan borrowers during the coronavirus pandemic. And so that litigation is pending, and there's briefing going back and forth, but essentially, the defense in those against those claims has been that it's not the Department of Education that is that's garnishing these paychecks, it's employers. So similarly, we see a number of litigations by single plaintiffs as well as class actions filed against actual employers who have been engaged in salary or wage garnishment in connection with student loans. Again, these folks are relying on the CARES Act in bringing those allegations. So that's what we're seeing in terms of trends. Turning to anticipated litigation, what we expect to see are a few things. The first is related to the Fair Credit Reporting Act. And so the CARES Act amends the Fair Credit Reporting Act and requires that when a furnisher of credit information offers payment relief or some other accommodation to a consumer that has been affected by COVID-19 and the consumer satisfies the accommodation, the furnisher has to report the consumer account as current. And so if the account was in a delinquent status prior to the accommodation, the furnisher can continue to report the account as delinquent until the consumer brings the account current, in which case the account must be reported as current. And so there's been some confusion as to how that's applied and whether furnishers of information are actually abiding by that. And so the CFPB has issued a non-binding policy statement regarding furnishers' obligations under the CARES Act and regarding the path forward. And so they've spoken to a flexible supervisory and enforcement approach during this pandemic regarding compliance with the FCRA. And at this point, there's really a lot of uncertainty as to how the requirements of the CARES Act could play out, specifically in consumer litigation. But the text of the FCRA still requires that furnishers respond to disputes received from credit reporting agencies, and they, under the statute, have 30 days in most circumstances to comply with those requirements. And so while the CFPB has decided that they're not going to bring any enforcement actions, or they're going to be lenient in their approach to enforcing the law in this regard, it's very likely that a consumer would still have a private right of action under the FCRA against a furnisher that may not be in compliance or didn't complete an investigation into a credit inquiry timely. And so because consumers are more likely to request payment accommodations from furnishers during this period, there could very well be an increase in disputes from consumers who claim that their accounts should be reported as current under the CARES Act, but for some reason were not. And in my practice, I've actually started to see some of these threatened and actual litigations popping up already. Another area where we anticipate litigation related to the pandemic is the Fair Debt Collection Practices Act, or the FDCPA. And so debt collection after the pandemic will certainly become the subject of many enforcement actions and private litigation too. And so, as I'm sure many of you know, the Health and Economic Recovery Omnibus Emergency Solutions Act, or what's commonly referred to as the HEROES Act, was passed by the House of Representatives in May of 2020, but it's considered to be dead on arrival in the Senate, and the President has promised to veto that legislation. But if it is enacted as law, the HEROES Act would actually implement debt collection-related restrictions that the House Democrats have been pushing for vocally during the pandemic. Namely, no debt collector can take or threaten to take a number of debt collection actions with respect to consumers, small businesses, and nonprofits. And some examples of the types of activities that would be prohibited by the HEROES Act include any enforcement of a security interest through repossession, limitation of use, or foreclosure, any collection of debt by way of garnishment, attachment, assignment, deduction, or other seizure from wages, income, benefits, bank prepaid, or other asset accounts, etc. Any action to evict a consumer from real or personal property for non-payment, or any disconnection, any attempt to disconnect or terminate services from a utility, including electricity, natural gas, telecommunications, broadband, water, etc. And so under the HEROES Act, violating the FDCPA provisions would be subject to liability as though they were debt collectors. So any violation, anyone who would violate any of those terms, and there are many more, under the HEROES Act would be treated as debt collectors under the FDCPA and subject to pretty stiff fines that could equal 10 times the liability that would otherwise apply. So there's very aggressive language in that legislation. And so for that reason alone, we anticipate that, if the HEROES Act is passed, and it's obviously very much up in the air at this point, there will likely be a large amount of litigation over FDCPA issues. But even if it isn't, we still believe that there will be a significant amount of litigation over debt collection issues generally.
So, Tanya, how are you counseling clients to prepare for this onslaught?
Sure. So, I'll tell you that I think in the world of consumer financial services litigation, the best thing to do is to keep accurate records on all consumer accounts. You want to be revising your protocols regularly and in tandem with the regulatory landscape, which is changing, pretty regularly. So staying on top of that is very important. We want to keep our employees trained and up to date. Business continuity plans are important. I mean, it's really all about flexibility and knowledge. Keeping your procedures updated, and, for certain financial services institutions, it may be the case that you need to adapt your offerings to consumers. So if they were typically not very online friendly or accessible outside of a face-to-face situation or in a brick and mortar office, ways of offering virtual services and things that can, are adaptable to our current environment. And just a quick word on bankruptcy. I mean, obviously, there's been a rise in bankruptcy filings. A number of companies have applied for these PPP funds and have received them and have, are holding out on filing for bankruptcy, even though it seems like it may be their last resort, and it may be advisable. I mean, obviously you have to consult with your own counsel, but it might be advisable to think about where you can cut back expenses and how you can, potentially hold out, because the longer you hold out, the more likely it is that those PPP loans could become a grant as opposed to a loan, and something that you wouldn't have to pay back.
Thank you. Terrific overview. Obviously, a lot to unpack there, but great overview. Let me turn it over now to Christine Argentine, who's going to tell us what she's seeing in the areas of class actions and Telephone Consumer Protection Act litigation. Christine?
Thanks, James. So class actions in the consumer and the employment context have already been on the rise for the last 5 years, and the COVID pandemic has done nothing but accelerate that. Since May, up until May, there were over 500 class actions filed related specifically to COVID issues, and that has increased throughout June and July. So some of the things that we've already seen happen in terms of class actions in the consumer space is that obviously we've seen the business interruption coverage claims come through, where businesses are banding together to challenge insurance coverages. It's a little bit surprising that these are being brought on as class actions, especially because it's a very fact-specific, contract-specific analysis that the courts have to do. But nevertheless, courts are letting them proceed as class actions for now. There's obviously been some legislation proposed both at the state and federal levels about forcing coverage in these instances, but none of that has gotten a lot of traction yet. Another area that we're seeing a lot of consumer class actions filed is in the breach of contract / unjust enrichment area. Several universities have been sued for tuition refunds as a result of having to convert to online learning. Membership-based businesses such as gyms, theme parks, ski resorts have been sued for refunds because those services are not available. Ticket providers, season ticket holders, sports venues, concert venues also have been sued. Obviously, those events were canceled, and they were sued for lack of refund or for trying to move the event as opposed to providing a refund. The third area that we've seen a lot of class actions filed already is in the consumer fraud area, right? Misrepresentations, mislabeling, false advertising on products. We've seen a lot of class actions filed with respect to products that are being promoted as, preventing the virus or helping to prevent the virus. And so a lot of those advertisements are being alleged as misrepresentations because those products don't actually do what the business or producer says they do. And then finally, as Tanya mentioned, with respect to the PPP loans, we're seeing class actions in that area, in addition to banks being sued in that area for allegedly reshuffling the paperwork and putting certain applications to the top. So what's coming next? And I won't go over all of these in great detail because we do have we're under a time restriction here. But first and foremost, we expect to see new ways of similar or the same class actions. So the tuition refund cases, a lot of universities have come out and said, we're going online for the fall semester, so we do expect that to be an issue with the plaintiff's bar. We also expect that to expand beyond the universities. Both public and private have been hit. We expect charter schools to be hit. We expect, we've already seen certain law schools to be hit, so that will be a trend that will continue. Again, membership-based businesses. Now that businesses are reopening, that membership probably looks different. And so whether or not those services being provided are the same or viewed as different or of less value is going to be a key target for the plaintiff's bar in terms of class actions. False labeling and misrepresentation claims, again, when businesses reopen, they're looking for ways to capitalize on the current environment, meet the current demand, but we want to make sure that the way we're labeling, the way we're misrepresenting those, the way we're representing those products is not done in a way that overstates what that product can do. Another area we expect to see a little bit of a wave of class actions is in kind of the privacy cases. There's a lot of new technology that's being developed very, very rapidly. Body scans, temperature checks, surveys being created to determine whether or not someone has symptoms. And everyone wants to know how the businesses are going to protect them. So one thing that businesses want to make sure of is that they're not running afoul of some of these privacy statutes that are in place that limit the collection of that information. Telephone Consumer Protection Act, this is a statute that is very, very popular already. We haven't yet seen a whole lot of COVID-related action, but as businesses reopen, they are all looking for new ways to reach a customer remotely. That's via text message, that's via phone call, or alternatively, new ways to offer contactless services. That's what consumers want, so that's what businesses are trying to give them. We want to make sure that the businesses are staying compliant with the TCPA as they do that. I want to touch quickly on the COVID exposure claims. You know, the claim that I went into a business as a consumer and I contracted COVID as a result of something that business did. There are budding laws that are looking to prevent that type of exposure, but note that those laws are very, very specific and will require very strict compliance with whatever the present guidance is, and so those are going to be very difficult laws to fall under even if they are enforced. And then also courts are really mixed on whether class treatment is appropriate for these types of cases. So the Northern District of Illinois, when looking at this in a prisoner situation, said that this is not an appropriate case for class treatment because the risk is different to everyone. Alternatively, the Southern District of Florida has found that it is appropriate for class treatment. So it's an area that we expect to see claims and class actions filed in, and whether or not the courts are accepting those as class actions is something that we're going to have to kind of wait and see. So how do we, as businesses, mitigate our risk against these really high exposure, really high profile cases? One of the things that you want to do is you want to review your policies, contracts, and procedures to determine whether or not they're reasonable for the present circumstances. What might have been reasonable 5 months ago may not be reasonable anymore. So you want to re-look at all of those policies and contracts and procedures with an eye towards what is going on now and what the reasonable consumers are expecting now. Additionally, you want to consider whether arbitration provisions or class action waivers might be appropriate. If you've been thinking about adding those to your contracts, now's the time, maybe a good time to add those. Currently, the law is very good for defendants enforcing arbitration provisions, and it'll protect you against some of these future disputes and lessen that exposure you might have in a class action context. If you do decide to add these types of provisions, you want to make sure you're giving appropriate notice to the consumers so that they know that these provisions are out there. You probably want to offer an opt-out option, and you also want to make sure you are following the laws with respect to the provenance of how those types of provisions are set out in your contracts. Another thing that we want to do to mitigate our risk is, you want to review your marketing materials, your labels, your representations that you're making, and look at it from a reasonable consumer perspective. Many state consumer fraud statutes will require, will base it on the reasonable consumer's interpretation of whatever the business is putting out there. So you want to re-look at what you're doing with respect to new materials, labels, and representations, and look at it from that reasonable consumer and what a reasonable consumer would understand you to be representing. I mentioned just previously about the new technology and the new efforts to protect against the virus. The CCPA was recently enacted in California. The Biometric Illinois Privacy Law is a big law that has a private cause of action under it, and then the SHIELDS Act in New York was recently put in place. All of these have different definitions of what protected information is, what physiological characteristics are, so you want to make sure you're reviewing those types of statutes prior to collecting any information from consumers. Finally, I'll just say very briefly, and this is going to, I'm sure, be a very reoccurring theme across our presentation, you want to follow, document, and revise procedures as the federal, state, and city guidance changes. You want to make sure you're keeping track of what you're doing to comply. All of that will serve as a greater defense in the event that you do get in a situation where you have class allegations against your company. So with that, I'll turn it back to James to talk about our next topic.
Thanks, Christine. Obviously, the takeaway here is that the plaintiffs' class action lawyers are looking for creative ways to bring a variety of claims against clients in a number of industries, so need to be prepared. Thanks for that overview. Let me turn it over now to Rebecca Woods, who's going to talk about the trends she's seeing in construction, real estate, and commercial litigation. Rebecca?
Great. Thank you, James. So first, we're seeing an increase in claims based on force majeure and the common law equitable arguments of impossibility, impracticability, and frustration of purpose. The force majeure clause is getting a very serious workout, moving from the obscure boilerplate provision to the front of the class. Similarly, equitable contract breakers of the impracticability, frustration of purpose, and impossibility that most lawyers learn in law school and then usually never grapple with are again being dusted off. I just this morning did a quick Google search trend, and it's showing that force majeure was hardly ever searched for since 2004. And in March of 2020, on a scale of 1 to 100, it hit 100. So lots of people are looking at those clauses. It's too soon to tell how successful this kind of cluster of the contract and the equitable arguments will be. As with many major tort-type claims, the jurisprudence around these COVID-19 arguments for relief is still undeveloped. The few cases we are seeing highlight the rule of thumb that, the initial rule of thumb, that specific terms of a force majeure clause and the contract as a whole are paramount when a party seeks to take cover. For example, many force majeure clauses do not excuse payment, but they do relieve a party of other performance, such as time or some other thing to do. And courts do appear to be enforcing that nuance. The second rule of thumb is the jurisdiction you're in and the circumstances of the case at hand matter greatly. Nevertheless, we do expect to see emerging general trends, with so-called judicial hellholes providing greater relief and lowercase c conservative jurisdictions providing more limited relief. On the real estate front, we're seeing and are involved in an explosion of cases for non-payment of rent. Most landlords and tenants are opting to take a business-sensible approach, frequently with amendments to the leases or other business negotiation. But many landlords and some tenants are opting to file suit, either to preserve their rights or to get leverage in settlement discussions. Those non-payment claims are having a collateral effect. They're bleeding up to the lender level, with lender covenants being triggered or in danger of being triggered. We're also seeing other emerging issues in the real estate area related to claims for right of access. For example, the landlords are in a whipsaw when they shut down amenity centers because of local orders, but they're contractually obliged to provide such access pursuant to the leases. We're seeing claims by and against third-party vendors for exposure issues, and co-tenancy appears to be a giant sleeper of a real estate issue. Many tenants are or will fail as a consequence, and that will trigger for other tenants their co-tenancy provisions. That has a huge potential to create a cascading effect on remaining tenants and landlords. On the construction side, we're seeing unprecedented delays. An already tight skilled labor market has taken a huge hit with these shutdowns and virus infections. Materials are also being delayed, especially those that are inbound from other countries, and inventories are weirdly lopsided because they're not following the typical rules. Exports are down, but local demand is also down. And delays are also being caused by the sheer difficulty of complying with local regulations and getting the work done. Many of these large delay claims, in our experience, take more than a year or so to mature into litigation, and so we expect those claims to come for quite some time. On the insurance side, the insurance market is incredibly hard hit, and people who never even think about insurance are seeing it in the news all the time. The only winners right now who are clear are the lawyers who are doing the coverage work. There's a tsunami of claims, particularly on the business interruption front, and we're seeing those start to be significantly rebuffed by courts. I saw a question from one commenter whether we're seeing any success, and the answer is it's extremely limited so far. AXA agreed to provide business interruption coverage for a pair of restaurants in Paris, but otherwise they're remaining in the super minority because property damage is required for those kinds of claims, and for the most part, property damage, and the courts conclude that virus doesn't create actual property damage. We're also expecting to see significant claims for bodily injury for those who are infected and those triggering third-party policies, so commercial liability, even directors and officers for making decisions on employer liability claims will arise. We're expecting to see a lot of fighting continued between insurers and policyholders as a time-honored tradition, and the application of exclusions, particularly the virus exclusion, expected and intended, and accident, are going to increase. And on the actual litigation front, we are seeing that civil suits are progressing incredibly slow, and we're going to talk a little bit about arbitration provisions and whether those should be considered for folks moving forward. So what can companies do to prepare? First, you're going to want to review your contracts, particularly those provisions that relate to force majeure, limitations of damages, indemnity, your insurance coverage requirements, and your litigation provisions, where, when, and how you sue. I want to pause for a moment on indemnity provisions in particular, because those are the redheaded stepchild of contract negotiation. The ones in your contracts are probably substantially the same boilerplate indemnity provisions that have been copy and pasted for years. The good and bad of the typical boilerplate indemnity provision is they're functionally useless. Most do not have an extant indemnity requirement. That is, most indemnity provisions require proof of liability before the indemnity obligation actually kicks in. Typically, there's no proof of anything until the underlying claim is resolved. And that functions to invite the indemnitor to participate in settlement negotiations, but a recalcitrant indemnitor can otherwise refuse and play chicken with the indemnity demand. This may be good or bad for your company, depending upon whether you're going to be an indemnitor or an indemnity, but it warrants a careful re-review of those provisions. And while looking at your contracts, particularly in light of the significant court delays that we expect to last well into 2021, if speedy resolution, dispute resolution is a priority for your company, consider choosing arbitration as an option. It's not always cheaper, but it should be faster. The one thing I'll note in particular, I know in working with clients, is that a significant source of concern for arbitration provisions is they typically can't be appealed. But remember that each of the major arbitration vendors have their own arbitration procedures. They require party pre-approval, and so if these are things you might want to consider baking into your contracts, check those required boxes when negotiating or amending your contract. And you heard it here first, but the landscape for insurance is going to change radically. Insurance was already a hardening market with higher premiums because of social inflation, climate change, and other major claims, and the pandemic is not going to help. So in light of that, you're going to want to make sure your broker is working with you to scale your risk and make sure that you have adequate coverage in place, but you're also going to want to think about how your company can protect itself in the event that either premiums are too high or coverage is limited. Virus exclusions will become universal. There is no doubt about that. On the construction side, those considerations, thinking about whether to provide forward-looking extensions, buying out delays, thinking about how to protect and mitigate against consequential damages, are things that we're talking about with our construction clients. And then finally, on the real estate side, there's already a major sea change in real estate and retail use, and the pandemic is only accelerating that. So landlords and tenants will want to be thoughtful in their negotiations and renewals, particularly around force majeure, co-tenancy, default triggers, and insurance requirements. So that is that, and I'll hand it off to the healthcare.
Thanks, Rebecca. It is amazing how this has taken us back to some of the basic contract principles that we never thought about since law school. And I'll make a plug for some of the litigators in our construction and real estate group who put together a terrific 50-state survey on the applicability of these various doctrines, which is available at on our website and has become a go-to resource for a number of our clients. Before I turn it over to Jesse, let me just provide the CLE code for folks. It is SS, as in Seyfarth Shaw, 0772. That's SS 0772. And with that, I'll hand it over to Jesse Coleman to talk about what he's seeing in healthcare, life sciences, and pharmaceutical. Jesse?
Thank you, James. With trillions of dollars being spent to prop up the national economy and various waivers being issued by oversight agencies to allow for more healthcare financial arrangements during the pandemic, we anticipate government and private enforcement actions for fraud, and particularly False Claims Act claims, to be aggressively pursued in the post-pandemic environment. My colleagues have already talked to you a bit about the CARES Act, considered the most expensive stimulus legislation in U.S. history, exceeding $2 trillion. This CARES Act stimulus includes state aid for pandemic-related costs, a provider relief fund, increased Medicare payments, expanded telehealth and home services, and funding for community health centers. Now, to access these funds, hospitals and other healthcare providers have had to make and will have to make 5 sets of certifications to the federal government regarding the reimbursement and the payment with regards to these funds, for which material misstatements may give rise to False Claims Act or FCA liability. In addition, CARES comes with new oversight agencies. There's the Office of Inspector General for Pandemic Recovery that will scrutinize the actions of the Treasury Secretary in distributing $500 billion in aid under the CARES Act. There's the Pandemic Response Accountability Committee to oversee all spending, lending, and other outflows appropriate under the law. And then there's the Congressional Oversight Commission to oversee the Treasury and Federal Reserve's implementation of the law. We anticipate that these agencies, and particularly the investigations by the SIG office, will give rise to extensive litigation in the post-pandemic world on how healthcare organizations use their CARES Act dollars. We also anticipate increased litigation in the realm of Stark and anti-kickback enforcement. As many of you know, CMS and OIG, the Center for Medicare and Medicaid Services, and the Office of Inspector General issued in October 2019 proposed rules that expand the types of healthcare financial relationships permitted under law and make changes to key terms such as fair market value and commercial reasonableness, and in addition allow for additional safe harbor for value-based medicine approaches. CMS and OIG have followed this up during the pandemic environment with additional waivers and policy statements allowing for further relaxation on financial relationships and remuneration related to COVID-19 pandemic care. But with all these relaxed standards, there will be ambiguity in their application as well as efforts to take advantage of lax enforcement. In the short run, during the pandemic environment, we anticipate that this will allow for an extensive amount of fraudulent billing, but in the long run will result in FCA claims and government investigations in the post-pandemic environment. These will take the form of litigation, as many of you are familiar with, involving government actions for both civil and criminal liability, as well as qui tam actions under state and federal law, where private plaintiffs will bring claims on behalf of the government in exchange for a percentage of the recovery. We also anticipate, and has been discussed somewhat already by my colleagues, increased provider billing fraud litigation outside the qui tam world. Moving over to data security, the HHS Office of Civil Rights, the OCR, recently issued a notification of enforcement discretion, allowing business associates to disclose personal health information for public health and health oversight. HHS has also recently allowed providers to adopt telemedicine platforms. This is a concept that's going to come back again and again that would not have historically met the criteria for HIPAA compliance, as well as waiving certain patient-centered HIPAA protections. Now, while some of these quote-unquote temporary relaxations announced over the past several months may be here to stay, covered entities remain liable for breaches of the HIPAA privacy rule, and OCR will continue to seek fines and engage in enforcement actions moving forward, particularly in the post-pandemic environment. We believe that the current uncertainty in this environment may actually give rise to more litigation over these issues as covered entities attempt to define the new boundaries. Moving now to FDA regulatory changes, the FDA has taken unprecedented actions during the COVID-19 crisis to bolster medical supplies, rush testing to market, and help to develop potential treatments. These actions have had both positive and negative consequences, which are just beginning to emerge. For example, during the crisis, FDA has stepped back from its typical gatekeeping role, allowing for some products to be commercialized without the FDA review or with much less evidence than traditionally required. We foresee that this trend will continue through the COVID pandemic environment, reflecting a shift away from prevention, but later towards enforcement, with FDA encouraging new testing products and treatments to reach the public as soon as possible. The back end of this issue, however, is the increased risk for private liability, which is only partially offset by corresponding immunity provisions under state and federal law. And that's what I want to turn to now. Both state governments and federal agencies have issued myriad regulatory waivers and statutory schemes allowing for immunities in the fight against COVID-19. Among the most promising is the PrEP Act, which provides a broad range of federal preemptive immunity for covered persons in the use of countermeasures. And all 50 states have issued complementary immunity statutory regimes, providing various layers of protection for healthcare workers and those providing services in senior living environments. Nevertheless, the application of these waivers and immunity remain largely untested, and we anticipate a broad array of claims to be filed against healthcare entities engaged in the use of COVID-19 countermeasures. And finally, in the area of medical staff and credentialing, COVID-19 has placed a tremendous strain on this country's healthcare resources, including the availability of qualified physicians and other healthcare workers. In an attempt to increase that number to combat COVID-19, federal and state agencies have again relaxed physician licensing requirements, waived certain conditions of participation in federally funded healthcare programs, and waived fees for mandatory background checks on physicians. These legal changes have assisted in expediting medical peer review and credentialing, and healthcare organizations are using these changes, along with various forms of temporary privileges permitted under CMS conditions of participation, to augment their medical staffs. But with the relaxed restrictions and expedited credentialing comes greater risk for incompetent medical care and adverse outcomes, and the attendant risk for personal injury claims increases dramatically for organizations in this environment. Ultimately, we do not see these risks subsiding until full peer review processes are reinstituted in a new post-pandemic environment and new and reapplying healthcare workers. So what can companies do to prepare for this litigation? Well, overall, we see a pandemic world creating an environment of lax government regulations, decreased accountability for use of government spending, and increased waivers for financial and healthcare arrangements that may have otherwise been prohibited. But the problems that give rise to the pre-COVID government regulation oversight have not gone away, and we anticipate both investigations and private suits to come back with a vengeance as we enter the post-pandemic world. Accordingly, we have the following high-level recommendations with a strong suggestion you consult with further legal counsel, such as the experts at Seyfarth. We recommend that you ensure all government expenditures and reimbursement requests are handled properly and documented meticulously. Follow HHS regulatory developments regarding Stark and anti-kickback rules. Those proposed rules have not been enacted, and there may be many changes to them before they are enshrined in regulation. We should ensure compliance and seek protection and immunities under federal agencies and waivers under the state statutes and the Federal PrEP Act. There is a question and response process that's built in to inquire with the HHS as to whether or not particular circumstances may in fact allow for immunity. We encourage you to stay up to date in telehealth and telemedicine developments. This is the wave of the future, and this is an area that will only be growing and will be fraught with risk, particularly with regards to HIPAA and high tech, but also with regards to the False Claims Act. We encourage you to seek collaborative COVID-19 pandemic countermeasure approaches. What that means is work with the local, state, and federal governments to look for ways to become part of their processes for fighting the disease, and this may in fact in turn lead to, for example, PrEP Act immunities. And then ensure all healthcare professionals employed or affiliated with your organizations are properly vetted and credentialed. I'd like to give a shout out to my colleagues in DC, San Francisco, and Houston for whose expertise contributed to this presentation. Thank you, James.
Thanks, Jesse. Can't think of an area that's been more affected by the pandemic than healthcare. So thanks for that overview. And Jesse and his group recently put out a treatise called "The Future of Healthcare in the U.S." What a post-pandemic healthcare system could look like. That's really a must-read if you're operating in this space. So feel free to reach out to Jesse to get a copy of that. Let me turn it over now to Kate Schumacher, who's going to tell us what she's seeing in securities litigation and enforcement. Kate?
Thanks, James. So the COVID-19 pandemic has already spurred private securities class action lawsuits and SEC enforcement actions. It is therefore critical that companies are mindful of how they treat and disclose news and forecasts related to COVID-19. I'm just going to give you guys a brief overview today of trends and some suggestions of best practices. But if you're interested, the firm has already hosted 2 webinars devoted to pandemic-related securities litigation and enforcement trends, both of which can be viewed through our website. So check those out if you're looking for a more in-depth look in this area. So what are the trends? What types of cases have been filed to date? About a dozen COVID-related securities class actions have been filed since March, largely against companies that are either directly involved with COVID or with a business model heavily impacted by it. These cases fall into a few different buckets. First, you have cases involving a failure to disclose the adverse impact of the pandemic on defendants' business. The best example of target companies in this group includes the cruise lines like Norwegian and Carnival, both of which have been sued in securities class actions. The second bucket are cases involving misrepresentations concerning the ability to sell and profit from products in high demand as a result of the crisis. Target companies in these matters include pharma or medical device companies purporting to sell or develop face masks, test kits, hand sanitizer, and temperature reading technology. Or even companies like Zoom, who are alleged to have failed to disclose the cybersecurity risks associated with the increased demand for their product during the pandemic. And as people have mentioned, there's even a securities case involving misrepresentations to investors in connection with participation in the CARES Act Paycheck Protection Program, PPP. A plaintiff shareholder recently filed a securities class action against Wells Fargo, alleging that the company made misrepresentations in connection with its participation in the PPP and unfairly allocated these government-backed loans under the program. Although not specifically related to COVID, M&A suits still continue to be filed as well. As of the end of May, there were over 60 deal-related federal security suits filed in 2020. So as long as M&A deals continue to go forward, we expect to see challenges to them. So that trend is likely to continue. On the enforcement side, the SEC has issued COVID-specific guidance in which it provided an illustrative list of topics that each company will need to assess carefully in considering the effects of COVID and on their related disclosures. When the SEC issues this type of guidance, it is a clear signal that public companies should very seriously, thoughtfully, and systematically evaluate the effect of COVID on all aspects of their business: operations, logistics, finances, controls, security, IT, and labor issues. The SEC appears to be acting quickly against companies it believes are misrepresenting the capabilities of COVID-19 related products, and in fact, enforcement actions have already been filed. And finally, the SEC Division of Enforcement has also been requesting information from recipients of the PPP and is scrutinizing eligibility for these funds and misstatements or inconsistencies between the application certifications and SEC filings. So, how to protect yourself? Take extra care in making public disclosures when discussing COVID-19 matters and include appropriate cautionary language and caveats. Follow the SEC guidance that's specifically related to COVID that I mentioned, and then also general securities laws on disclosures, and document compliance with these processes. Ensure full documentation of all management analyses and board deliberations related to COVID-19 matters. And finally, take reasonable steps as a board to mitigate risks and proactively address concerns. So some proactive measures would include creation of COVID-19 focused board committees, focus on succession and continuity planning, ensuring robust information flow, IT and financial controls testing, increased cybersecurity protections, protection of confidential information during remote work, ensuring active liquidity and debt management, and finally, being mindful of financial and credit developments which jeopardize the corporate ratings of the company. I'll turn it back to you.
Thanks, Kate. Obviously, uncharted territory here for companies and their boards, and I know you and your team are working closely to help them navigate through some of these issues. Thanks for that overview. And for our final segment, let me turn it over to Rich Lutkus, who's going to talk about what he's seeing in the area of trade secrets and cybersecurity and privacy. Rick?
Yeah, thanks, James. So I wanted to talk through a couple of, I know these topics are somewhat broad, but I'm going to try to summarize what we're seeing and what we're expecting out there in the world of cybersecurity, privacy, and trade secrets cases. One of the things that I think you'll find, and the themes that have come out of our presentation today, are that companies are more focused right now on running the business remotely with remote workers and a little bit less concerned about protecting their data. There was a lot of reactivity when people started working from home initially, and a lot of the IT departments in companies across the world had to essentially support remote workers almost on the tick of a clock the very next day. And so we're seeing a lot of repercussions from that, where security systems were tuned down in order to allow remote work. So the first thing we're seeing in the world of cyber are data breach litigation related to those reduced security protections, with remote workers. A lot of what's been happening is employees have been allowed to use whatever devices they have at home rather than corporate assets to conduct their work. And in some cases, those employees have also used their own private cloud services, sharing services, and other systems to conduct business. Essentially, they're taking a practical approach of, hey, I need to do my work. I'm going to take whatever steps necessary to do it. And as a result, it's put some data at risk, especially for people that handle sensitive data like HR data, PII, PHI, and things like that, financial data included, and trade secrets, obviously. We're also seeing some issues related to legal hold compliance where companies who have legal holds in place now have another source of data to potentially collect from. We're calling this data repatriation, where we're trying to get corporate data back into the environment properly and also make sure that it's maintained for legal hold reasons. So, this is a situation that we're seeing companies contend with where data is being, created on personal devices at home where it normally wouldn't have been. And now they have an obligation to try to collect that data in a complete way without violating any privacy rights of the individual employee. So these are two areas I think to be aware of in relation to cyber and e-discovery compliance. In terms of privacy, this is somewhat related. We anticipate there will be some privacy-based litigation on the mishandling or improper processing of employee or customer data without adequate controls. And this is somewhat related to the cyber issue of reduced controls over data flow. Obviously, in privacy law, there's a lot of focus put on, who's a proper processor of data and how that data is processed and how it flows from a corporation to its third parties and employees. And so we expect that, as the remote work continues, companies will discover situations where their own employees or third parties may have mishandled data as a result of having that data on systems that it was not intended to be on. The third part, trade secrets, I think this is somewhat obvious, but with remote workers and especially with mass furloughs and layoffs, employees that have lost their jobs are trying to find ways to find new work, and part of that could involve removal of data or prior employee data when they go to their new employer. So there's a pretty good risk here, given that employees may and likely have corporate data on personal assets. Misappropriation cases are probably top of the list. We also think solicitation of customers, former colleagues from their former employer, potential spoliation of data that they do have are all risks in the trade secret world. So be aware of that if you have any remote workers. In terms of how to deal with these, I want to put together just a top 6 list of what I think could help mitigate some of those risks. The first one is really strive to enact policies and have practices that enforce the security of data flow. That means, if the data is going outside of the corporate network and it's going to employees who are remote, put some things in place that will actually allow the company to control that data. And that could be making sure that employees are using Citrix or other remote virtual technologies instead of using personal computers to connect to corporate networks. Second one is requiring those remote workers to use corporate assets. If you don't have a Citrix environment, provide them with a laptop, provide them with a VPN or some other way to connect into the corporate network. That way the corporation can actually use data loss prevention tools and other detection software to ensure that data is being kept as it should under normal data retention policies. And part of that is what we consider in the industry, in the cybersecurity industry, as zero trust, is any device that's not a corporate asset with corporate protection software and monitoring is considered a zero trust device. And that means that you shouldn't have employees' personal devices connecting to your corporate network over VPN. And the reason for that is a lot of times people's individual antivirus and anti-malware software is nowhere near as robust as any corporate provided systems are. And so what you have is a very insecure device connecting to what you want to be a secure environment, that is your corporate network. And what happens is because it's a personal device, it doesn't have as much protection and is therefore creating a greater risk to the corporation by virtue of being connected. So we recommend that companies go to using solutions like Citrix or providing VPN services with an actual corporate asset like a laptop for employees to use. Another method that actually works fairly well at trade secret cases is using digital fingerprinting technology to track key documents. And the way this works is it will actually imprint a section of text internally to the document that's indistinguishable to any viewer, but is easy to search for with data loss prevention tools. So when a document is forwarded and goes through the email systems, that attachment can be discovered easily by data loss prevention tools and stop the delivery of documents to to locations outside of the environment. So it's a really interesting technology, and also helps if they do manage to get the document out of the environment in some other way. Let's say they use a USB device and it ends up on their computer. Doing a remediation through a forensic examination becomes a lot easier when you have digital fingerprints to search for. You can search exactly for what you're looking for and find it quickly. Last 2 points, we recommend auditing high-risk employees to find out, whether they are harboring any corporate data. And part of this would naturally flow to those who are handling corporate finance data, HR data, healthcare information, and anything related to PII of your customers or payment card information. One of the ways we've addressed this at Seyfarth is we've developed a product called Seyfarth Scout, which allows us as counsel to assist clients in performing those assessments and data collections. It works over the internet. It can be deployed within under an hour, and we can have early indications about whether an employee with a remote computer has been keeping data off of the corporate network. And lastly, ensure your legal hold compliance through planned data repatriation and what we're calling data amnesty programs. One of the things that I think is going to happen as people come and return to work is you're going to have to take the data that they've had off the corporate network and find a way to get it back into the network and have that data properly organized and fall under your normal retention schedules. And so part of that is a data amnesty program where you want employees to come forward and say, hey, I have these documents. I don't want to get in trouble just because I had them. And so these data amnesty programs essentially allow employees to come clean and return the data without any repercussions of the fact that they've had it. So that might be something to consider if you have employees that, potentially at the beginning of the COVID shutdown were using a lot of personal devices, and perhaps your information security teams added security as they went, but no one ever went back to get the data that was initially taken off network. So anyway, those are my thoughts. I'll turn it back over to James.
Thanks, Rick. Really interesting, some of the challenges that we're facing in the cybersecurity and privacy area from, most of the world going to a remote environment. So thanks for your feedback there. Unfortunately, we're running short on time. We've got a number of questions that we're just not going to be able to get to, but we'll follow up separately on those with some answers as a follow-up to the webinar that we'll email around to folks. All of the content that we have put out regarding COVID-19 is available on our Seyfarth website at our post-pandemic recovery and renewal page. So feel free to visit it and peruse around. There's a lot of great material there. We'll also be distributing a summary of the trends that our panelists have gone over today to everyone that's registered for today's webinar. So be on the lookout for that. And I just want to thank the panelists for doing a terrific job on covering a vast amount of information in a short amount of time. And I know they worked very hard to put their thoughts together. And I found it very interesting. I hope you did. And thank you all to the participants for joining. Hope you enjoyed the presentation. Look forward to presenting again. So take care, be safe, and be well.
This concludes today's webinar. Thank you for attending.